All rise, vous l'avez. Please be seated, vous vous asseoir.
Yes, Ms. von Bissinghausen.
Yes, Madam President, Your Honours. Before I respond to the defence submissions, there are two things I would like to say. I will deal with most of the defence submissions, but my colleague, Maître Beaulieu-Lucier, will speak about the applicability of Sudanese law after me. Before I start to get into the details of what the defense said, just a few general words. Your judgment, the trial chamber's judgment of 6th October, we know after consultation with clients holds a profound significance for the 1,592 participating victims that I'm representing today, as well as their families and their community. They feel they are finally obtaining some form of justice, even if it feels like a drop in the ocean compared to the real suffering, be it physical, psychological, material. The time elapsed since the events in 2003 and 2004, and the current and ongoing and seemingly never-ending suffering. We have undertaken, after the issuance of the judgment, both in-person and remote consultations. Right after the judgment, that was screened in 5 different locations for the participating victims in Kudum, Bindisi, Mokjar, Delej, and Kalmakamp. I was able to gather as many views and concerns as possible regarding the determination of the appropriate sentence to be imposed upon Mr. Abd-Al-Rahman. The extensive opinions and positions my clients have expressed on the matter are set out in detail in our written observations. In a nutshell, and after I have explained to them the ICC legal framework on sentencing, they have expressed trust in the court, in your honours, to determine the appropriate sentence to be served by Mr. Abd-Al-Rahman. Importantly, and repeatedly, and without exception, the participating victims have widely voiced the unwavering position that Mr. Abd-Al-Rahman should not be allowed to come back to Darfur. I could stop here and sit down. However, the sentencing submissions by the defense on behalf of Mr. Abd-Al-Rahman are of such nature that they can't be left unanswered. I do understand how difficult it is to advocate in favor of a lenient sentence for Mr. Abd-Al-Rahman, given the trial chamber judgment and him having been found guilty of the gravest international crimes, war crimes and crimes against humanity, such as murder, pillaging, outrages upon personal dignity, persecution on political, ethnic and gender grounds, rape, torture. And Mr. Nichols has brought back all the findings of the trial chambers before us, and I would say they speak for themselves. But what the defense is asking for is, in my very humble submission, both unreasonable and, in my view, legally wrong, and I owe my clients a determined response to the submissions made. So first, I want to speak about the gravity of the crimes. First, among the general considerations of the gravity of the crimes committed, the defense perfectly rightly notes at paragraph 14 and 15 of its submissions that there is no hierarchy among individual modes of liability. The sentence depends on a concrete assessment of the degree of participation and the degree of intent in the particular circumstances of the case. So there's a quantitative and a qualitative standpoint. Mr. Abd-Al-Rahman was convicted of all crimes committed in the Mukjar and Delej operations as a co-perpetrator, and additionally of the crimes of murder in Delege only, torture, outrages upon personal dignity, and persecution as a direct perpetrator pursuant to Article 25(3)(a) of the statute. He was the co-perpetrator, and Mr. Nichols reminded us of this, of the killing of 53 persons in Mukjar and 114 persons in Delege. All killings were perpetrated in 2 days. At least 3 children and 8 community leaders were killed. In Delege, he personally murdered 2 victims, Genif and Sheikh Motor, the latter in open public outside the Delege police station. And he did so with his axe. This is just the tip of the iceberg, and none of these factors play in favor of Mr. Abd-Al-Rahman. To the contrary, the gravity aspect was addressed in extenso in our observations in paragraphs 54 to 87. I therefore refer to those. Second, the defense rightly sets out at paragraph 16 the factors to be considered as aggravating circumstances according to Rule 1452b of the rules. Apart from prior criminal convictions, Mr. Abd-Al-Rahman ticks all the boxes: abuse of power, commission of the crime where the victims are particularly defenseless, commission of the crime with particular cruelty or where there were multiple victims, commission of the crime for any motive involving discrimination. And again, Mr. Nichols filled all these with life this morning. The judgments speak volumes about each and every factor that Mr. Abd-Al-Rahman has fulfilled, and the Chamber's findings need not be repeated. Also, there is no doubt that the commission of the crimes was foreseeable. The consequences of a crime or offense in relation to which a person was convicted may be considered to aggravate the sentence in one way or another, if these consequences were at least objectively foreseeable by the convicted person. The Appeals Chamber has also held in the Ntaganda case that the particular cruelty of certain crimes must also have been objectively foreseeable to the convicted person in order to be taken into account as an aggravating circumstance. Here I'm just citing a couple of examples. Paragraph 433 of a trial chamber judgment, and I quote, "Members of the Janjaweed stripped the women of their clothes and used this to stuff the women's mouths to stop them from screaming." End of quote. Another passage in the trial chamber judgment, paragraph 894. "They snatched an infant from its mother, threw it into the air, and let it fall to the ground." End of quote. Many Janjaweed acts showcase the particular cruelty of the crimes committed, and not only when we're talking about torture, but also related to all the other crimes that Mr. Abd-Al-Rahman was convicted of, and that it was foreseeable just considering the derogatory and discriminatory language used by the Janjaweed, particularly towards the Fur people. The Chamber also found, for instance, that the armed conflict's impact on the civilian population, where the number of civilian casualties considerably exceeded the combatant casualties, was foreseeable in light of prior large-scale military campaigns in Sudan. Further, the Chamber was satisfied that the members of the Janjaweed were aware that the transfer or displacement of victims would occur in the ordinary course of events, and that the impact on the civilian population of a large-scale armed operation in Sudan, such as the Kudum and Bignisi operation, was foreseeable. So now the defense suggests that the low rank of Mr. Abd-Al-Rahman should be taken into consideration when assessing the appropriate sentence for Mr. Abd-Al-Rahman. The trial chamber unanimously found that Mr. Abd-Al-Rahman had the highest authority over the Janjaweed. The defense is now attempting to relitigate this finding through the back door under the guise of sentencing submissions. Trial Chamber 7 in the Bemba et al. Case made it clear that sentencing is not the right forum to challenge how the chamber reached its conclusion, as this would improperly transform the sentencing process into a request to reconsider the judgment. Similarly, Trial Chamber 10 in the Al-Hassan sentencing decision confirmed that any such challenges to the factual and legal findings of the trial judgment are inapposite in the sentencing proceedings and are to be made before the appeals chamber rather than as part of the sentencing submissions before the present chamber. This is precisely what the defense is doing here, and this argument should fail on that basis alone. Moreover, Mr. Abd-Al-Rahman wasn't the highest authority. This is not in its... Moreover, if Mr. Abd-Al-Rahman wasn't the highest authority, this is not in itself a mitigating factor. Many accused before the ICTY, for instance, were not the highest ranking officials, but were still in a position of power and committed serious crimes. They did not receive mitigation for committing crimes in a position that was not the highest. This is not the point. What truly matters is how the authority was exercised. Where an accused held a position of authority, commanded respect from subordinates, and abused that position to order violations of international law, it was rightly treated as an aggravating factor and certainly not as a mitigating one. Here, the accused did not act under pressure or reluctantly. On the contrary, he carried out these crimes with enthusiasm, one could almost say with zeal, and partly, as the chamber found, as direct perpetrator. As a result, this argument must fail and cannot be given any weight in the determination of the sentence. To the contrary. Further, the defense suggests that obeying to orders was mandatory. The defense here recycles its argument at trial, so-called defense line 3, that relied on a mistake of law, according to Article 32.2 of the statute. They say it must be relied upon as a mitigating circumstance. The defense suggests that Mr. Abd-Al-Rahman didn't know that his conduct would amount to crimes under international criminal law, thus negating the required element of knowledge under Article 30 and 32.2 of the statute, and therefore could mitigate his sentence under 145.2a and I. The defense is also arguing that Mr. Abd-Al-Rahman was under the impression that he did not have the choice to obey orders following Harun's speech in August 2003 in Mukhtar, when Harun instructed the Janjaweed the kill, loot, and rape. In the Yongwon case, the chamber rejected such an attempt by the defense to revive their argument submitted at trial on duress for the purpose of mitigating the sentence. The trial chamber, a conclusion that was later confirmed by the appeals chamber, rejected this argument on the basis that the defense relied on the same facts at the sentencing hearing than initially during trial, and that the chamber had already assessed all the evidence and had rejected the interpretation of the defense and rejected their submissions at sentencing on exactly the same basis. Therefore, the defense argument must now fail the same way it did at trial. But for the sake of argument, I would like to remind the chamber of this. At trial, defense witness D16 had explained, as we have already submitted in our final trial brief, that the military legal structure under the 1986 Military Act did distinguish between lawful and unlawful orders, and would entail criminal responsibility for both the issuer of the unlawful order and the individual who executed such order. Additionally, D16 rejected the suggestion that the refusal to obey an order would incur an immediate risk of imposition of the death penalty. Instead, and I would say unsurprisingly, the practice in such a situation was often informal resolution attempts with formal procedures, including court process, with assigned counsel for the accused, taking place thereafter, if necessary. In its trial judgment, the chamber considered at length the argument of the defense and found that, and I quote, "a reasonable person in the position of the accused would not have been deceived into believing that his acts and conduct during the charged events were legal or justified. And this is at paragraph 59 of the trial judgment. The trial chamber also already found that it is immaterial whether the accused received training in IHL. The defense did not submit additional evidence or arguments that warrant reconsideration of this argument as a mitigating factor. To the contrary, the defense relies on the fact that witnesses were afraid of the speech given by Harun and believed that Harun had the authority to give such orders. However, being afraid of something does not per se establish that a reasonable person in the same situation would have assumed that the order was mandatory. It's a pure assumption made by the defense. It has no basis. It should be rejected. If we look at the testimony of witness P0903, he testified, and I quote, "When I heard this, I got scared, and I am of Fur ethnicity, and Harun's speech was obviously targeting the Fur. Hence, I decided to leave the market immediately and did not hear the rest of his speech." And he continues by saying, "Because what he said is dangerous, and I was afraid, and so I left." Witness P0922 did not specify in his testimony that he was afraid of the speech, but simply that he heard Harun giving that speech. Nothing about questioning the authority of Harun. And P0916 didn't specify either that he was afraid of the speech, but simply that he heard Harun giving that speech and that it was his opinion, that the looting started because of the speech. And actually, Judge Korner, during the hearing, intervened to say that this wasn't really something he could tell. He could only attest to the speech and what happened after that. Witness P0984 doesn't address the content of Harun's speech at all and does not speak of any fear felt by the people present that would indicate a necessity to obey orders. He speaks of an instance where Harun is shown respect and given space to walk. This is not sufficient of an indicator that he possessed the required legal authority to issue orders. The chamber in its judgment found that Harun did not have the legal authority to give such orders, and no witness testified that they felt compelled to follow such orders. Even if Mr. Abd-Al-Rahman had followed orders, he could not have thought that such orders were not a crime. A mistake of law can only be a valid defense if the accused is unaware of a normative objective element of the crime and if he doesn't realize the social significance. However, there is nothing ambiguous, culturally or socially, about the criminal nature of an order instructing someone to kill, loot, or rape. This argument failed at trial, and it must fail again. Even applying the standard of balance of probabilities, I can't see a glimpse of a positive conclusion to draw for Mr. Abd-Al-Rahman. Nowhere does the evidence establish that the accused, during the relevant period, held a formal military rank, was otherwise formally part of the government of Sudan Armed Forces, or under a legal obligation to obey formal military orders that may have been issued to him. The orders were so manifestly unlawful that Mr. Abd-Al-Rahman rather would have had an obligation, contrary to the defense argument, to disobey them, if anything at all. In the Bralo case at the ICTY, the chamber concluded, "It is the duty of any person involved in an armed conflict to comply fully with the relevant norms of international humanitarian law. And while Bralo may have been pressured to participate in combat activities, he remained legally and morally obliged to conduct himself in accordance with those norms." The trial chamber recalled, for instance, the particularly brutal treatment of a particular witness by Mr. Bralo, his participation in the killing of numerous civilians, including children, and his humiliation of civilian detainees by forcing them to perform a religious ritual. All of his actions the chamber found, displayed his complete contempt at the time for the laws governing armed conflict, along with a shocking disregard for the value of human life and dignity. And there is similar jurisprudence from the ICTR in the Nsengiumva and Tabakuse case, which we can provide to the trial chamber if required. In the present case, the orders were so manifestly unlawful that even if crimes against humanity and war crimes were not introduced under Sudanese law before 2006, Mr. Abd-Al-Rahman should have refused to implement the order. No evidence has been submitted and no argument made that he made any attempt to resist the undertaking of the crime he committed. Furthermore, there is no evidence that he ever received explicit orders of any nature. Coming back to our case, the enthusiasm with which Mr. Abd-Al-Rahman carried out the operations and committed crimes as a direct perpetrator is miles away from supporting the conclusion that Mr. Abd-Al-Rahman felt that the orders were in any way mandatory and or that he merely followed orders. We have said it before. The defense's position is impermissibly vague and lacking the detail necessary on the basis of specific facts, claims under Articles 30 and 32, which concern the accused's actual mental state. This is the natural result of the defense's primary position that Mr. Abd-Al-Rahman had nothing to do at all with the charged events. While a defendant may advance positions and assert claims under Articles 30 and 32 of the statute, the efficacy of such positions is founded on an acknowledgement that an accused was present at relevant events and committed certain acts. An accused who removes himself completely from the scene can hardly muster a credible position based on hypotheticals as to how their mental state and behavior was actually impacted in the circumstances. As such, these submissions should not have any bearing on the lowering of the sentence. I'm turning now to potential mitigating factors that the Chamber would have to consider as the defense suggests. To make it very clear, in the view of the participating victims, there are none. My clients find it even hard to accept that this is being debated here. But I guess my duty is still to address these submissions. First, the defense is seeking leniency on the pure basis of Mr. Abd-Al-Rahman's age. However, it is mistaken, we say, to suggest that the accused has a legitimate expectation of being reunited with his family. This is not a relevant element the Chamber can take into consideration in assessing the appropriate sentence, even less to constitute a mitigating factor. Second, the defense is seeking mitigating credit on the basis of Mr. Abd-Al-Rahman's health situation. I accept that it is constant jurisprudence at the court that health may constitute a mitigating factor, but only in extreme and exceptional cases, like a very serious health condition of the convicted person or perhaps a terminal disease. In the case at hand, Mr. Abd-Al-Rahman, aside from his age, does not show any serious health condition. The defense did not, from what I have seen, present any compelling medical evidence establishing that Mr. Abd-Al-Rahman had a specific medical condition during the years of his detention. He addressed the trial chamber at the end of the trial proceedings, and he intends to address the chamber once more during this hearing tomorrow or the day after tomorrow. He is able to formulate clear and coherent thoughts. Of course, in general terms, poor health can be considered if it becomes relevant in the future early release application. A health and therefore humanitarian situation can therefore have some weight later down the road, but not for sentencing purposes. And I don't go further into detail because we would have to go into private session, and I think Mr. Nichols has addressed everything that is relevant. Looking at Mr. Abd-Al-Rahman's family circumstances that the defense is putting forward, I don't even mention my client's reaction to such a suggestion, which I think all of us can blindly imagine, given the consequences of the crimes committed by Mr. Abd-Al-Rahman had on them and their families. I'm trying to be objective, and although it may seem unfair, and while the Katanga Chamber did consider family circumstances as a mitigating factor, this is no longer the case in the court's jurisprudence. In recent developments of jurisprudence on sentencing, ICC chambers have not given any mitigating weight to family circumstances, such as having received few family visits, the death of relatives while on detention, or living in dire conditions. I would therefore leave this factor to the discretion of the chamber if it wants to take another route and consider it to warrant a mitigating factor. Turning to the defense suggestion that Mr. Abd-Al-Rahman played a role as mediator. The defense suggests that Mr. Abd-Al-Rahman played a substantial mediating role in tribal conflicts and protected human life to an extent that warrants mitigation of his sentence. And the defense is going as far as to portray Mr. Abd-Al-Rahman as a man of peace. Almost needless to say, this is an unacceptable interpretation of the trial judgment and assessment of witness testimony at trial. For support, the defense cites the trial chamber in its findings in relation to the testimony of P0932 and P0958. The defense is simply misinterpreting, first, the trial chamber's words by stating that the trial chamber said that Mr. Abd-Al-Rahman played a role as a man of peace, and second, the witness testimonies themselves. In concrete, this is what the witnesses said. P0932 testified about seeing Mr. Abd-Al-Rahman amongst other notables during a cattle negotiation that took place in Garcilla in 2000. Initially, at trial, the defense contested the fact that P0932 attended such an event at all. First, the defense cannot have it both ways. But in any event, acting as a mediator in a cattle negotiation at a time and in a location irrelevant for the charges does not come close to warranting the title of man of peace. P0858 testified about a problem that happened between the Janjaweed and villagers when a weapon was stolen. Mr. Abd-Al-Rahman said that the weapon had been found and that this resolved the matter. And the witness also testified about the fact that Umda and Sheikh would bring complaints to Mr. Abd-Al-Rahman's office in Garcilla to have him resolve those complaints. However, with regard to the complaint concerning the rape of 2 women, P0858 stated that Mr. Abd-Al-Rahman did nothing. He did not investigate nor create a committee to assess the situation on the ground. This can hardly, I would say, be described as the behavior of a man of peace. The defense also relies on their new witnesses, D40 and D41, concerning Mr. Abd-Al-Rahman's initiative to promote peace in Rad el-Berdi. However, even if accepted by the chamber, efforts to mediate between tribes from 2009 to 2014 are highly irrelevant here. In their submissions, the defense is also citing the Ntaganda sentencing decision. It is therefore noteworthy that none of the assistance and pacification efforts made by Mr. Ntaganda was taken into account as a mitigating factor in his case. So even applying the standard of balance of probabilities, none of the defense suggestions made here, even if they were true, can have any mitigating effect on the sentence. Also, from the perspective of the participating victims whose views are guiding me here, and after the findings of the trial chamber, it amounts, and I'm sorry to say, to a certain level of cynicism to call Mr. Abd-Al-Rahman a man of peace. I'm now turning to the alleged direct interventions of Mr. Abd-Al-Rahman to preserve life. The defense further argues that Mr. Abd-Al-Rahman took direct action to protect and preserve life in circumstances that had nothing to do with an intent to benefit from a common plan. In this context, it lists two examples which should trigger mitigation of the sentence. The first is an event from 1986 in which Mr. Abd-Al-Rahman is said to have saved a man's life. However, more than anything, this is proof of the lack of better evidence to demonstrate Mr. Abd-Al-Rahman's selflessness and bravery, as the defense calls it. First of all, the trial chamber has generally given limited weight to D007's evidence, as it was considered of poor reliability and credibility. Also, even if mitigating circumstances need not directly relate to the crimes of which the person is convicted, and they are not limited by the scope of the confirmed charges, there must at least be some link. The incident that the defense cites took place almost 20 years before the charges in question. It is therefore irrelevant to the case at hand. This is particularly true given that Rule 1452A II of the rules refers to, and I quote, the convicted person's conduct after the act. Insofar as the defense argues that there are women from Arawala who are alive today and others who were saved from sexual violence due to Mr. Abd-Al-Rahman's order to Janjaweed and to Muqaddam Idris, this is indeed, as the defense concedes, at the very least, a very unattractive assertion to make. The defense sets out that P0905 provided evidence that Mr. Abd-Al-Rahman ordered Janjaweed fighters to spare women in Arawala from death. Leaving aside the fact that the defense previously called P0905 a liar, the defense is taking this statement completely out of context. The full statement of Mr. Abd-Al-Rahman was as follows, and I quote, "Anything you see, you have to kill or wipe. So no man has to stay alive. Women can be spared." End of quote. Thus, the defense is nothing but window dressing Mr. Abd-Al-Rahman's brutal actions against the poor population by portraying the very discriminatory nature of gender-based persecution as a heroic act of Mr. Abd-Al-Rahman. The fact that women were not predominantly attacked is merely the logical conclusion of gender-specific persecution, namely that a certain part of the group is specifically attacked because of their gender, in this case the men. That Mr. Abd-Al-Rahman simply chose not to end the lives of women, as he did with the lives of 4 men, is exactly part of the common plan found by the chamber and is so far from being a positive act to save women's lives. Quite the contrary. Women were never spared from brutal and violent attacks of the Janjaweed. The witness called by the defense states that every time Janjaweed went to war, they never killed women. They would instead torture and rape women. Overall, those women are not alive because of Mr. Abd-Al-Rahman, but despite the devastating social and economic consequences that have disproportionately affected women in the aftermath of the gender persecution conducted by Mr. Abd-Al-Rahman. In fact, the severe, multifaceted, and transgenerational impact of the crimes on women and children should constitute an aggravating factor for sentencing. In any case, though, the last thing these women do owe their lives to him, I say that again, in any case, though, the last thing these women do is owe their lives to him, as insinuated by the defense. Secondly, the defense set out that Mr. Abd-Al-Rahman ordered Muqaddam Idris to protect women and girls at risk of rape from Arab fighters, and that he made efforts to prevent rapes. The defense alludes to an incident in which the Janjaweed killed a man and a woman during labor, and Mr. Abd-Al-Rahman is said to have claimed that women should not be killed. It is obvious that no lives were saved in this case. The woman and her child had already been killed by his subordinates. According to P0905, there wasn't even an investigation or punishment following this incident. His subordinates, therefore, had no serious consequences to fear. There remains one action by Mr. Abd-Al-Rahman that the defense put forward, namely when he allegedly ordered Muqaddam Idris to bring women and girls who had already been raped by the Janjaweed under their surveillance and to investigate what had happened. Even if true, previous jurisprudence from the ad hoc tribunal suggests that such a passive and unspecific level of assistance and intervention without any direct effect on the well-being of the victims cannot be considered as life-saving and warranting mitigation. Instead, a positive and concrete action of at least some benefit to the endangered individuals in question is required, such as using exceptional means to save a person, helping them to escape, actively hiding them or assisting them to hide, or taking multiple actions to alleviate the appalling conditions of detainees. And we are pointing to ICTY jurisprudence that we can pass on to the Chamber if required. Furthermore, acts demonstrating benevolence on only single occasions, while at the same time directly perpetrating crimes during the same period, merely point to inconsistency in behavior and therefore was not given undue weight. By this standard, Mr. Abd-Al-Rahman's conduct does not demonstrate any concrete protection against a specific danger to women and girls. Rather, it must be viewed in the context of his numerous crimes and can certainly not be considered as a mitigating circumstance. In the role that I have here, I can only repeat the powerful message already cited in our written observations conveyed to Your Honours by V001 about the impact the crimes committed by Mr. Abd-Al-Rahman specifically had on women, and I quote, "The suffering in our communities is too much, especially the Darfuri women, the one who was raped, the one who lost her husband, and the one who is alone now. The Darfuri woman is tired." End of quote. I would like now to turn to the defense suggestion that Mr. Abd-Al-Rahman attempted to create solidarity across ethnic lines and his general good character. After all I've said, maybe a bit unnecessary to address, but just a few words. The defense is trying to portray Mr. Abd-Al-Rahman as someone who contributed to bridging gaps between the different tribes and who created solidarity across ethnic lines by daily acts of hosting, feeding, and assisting families, including those of the Fur tribe. To support this argument on solidarity, the defense relies on its own witnesses. At the outset, it is noteworthy that the trial chamber awarded little credibility to D3, D8, D39. If any, their testimony was considered regarding the fact that they knew the accused by the name of Ali Kushayb. So even if we take it on a balance of probability standard, the chamber found D3, D8, and D39's testimonies implausible, contradictory, unconvincing, and this is why little weight was afforded to those witnesses. This is not a question of standard beyond a reasonable doubt, a balance of probabilities, as suggested by the defense at this stage of the proceedings, but of the relevance, reliability, and general credibility of these witnesses. Also, it is noteworthy that none of the witnesses are of Fur ethnicity, which makes it less relevant and strong, if at all, to rely on them with regards to Mr. Abd-Al-Rahman's contribution to ethnic solidarity. In any event, these witnesses did not testify on specific issues relating to tribe solidarity. As for D40 and D41, their testimonies relate to facts from 2009 onwards and are therefore irrelevant in the present context. The testimonies relied upon by the defense also stand in stark contrast to all the derogatory and discriminatory language that the chamber found Mr. Abd-Al-Rahman was using against the Fur people. The accused saying words to the effect, and I quote, "You escaped from Arawala and then you came here. Even if you fly to the sky, I will get you." The chamber further recalled that while physically assaulting the detainees at Mukjar police station, the accused hurled derogatory terms such as slaves, magus, Tora Bora, and rebels. In the presence of the accused, some members of the Janjaweed told P0986, and I quote, "You slaves, it is you year, this year, you will all die." And then there is the sorry video, and there is the teacher's video. And I spare you the details of what they say, but just one quote from the teacher's video: "I'd have stabbed and killed any individual who mocked Raad al-Berdi or denigrated the teacher." Furthermore, daily acts such as hosting and assisting families of people from the 4 tribe may be a kind gesture appreciated by the community, but it does not constitute a mitigating factor for the purpose of sentencing. And lastly, if it ever happened, being generous and standing by the poor when it is not related to the conflicts and the crimes for which Mr. Abd-Al-Rahman was convicted has no weight. The defense, at paragraph 67 of its submissions, also highlights the importance of the work of a pharmacist in locations in rural Darfur, and that it cannot be overstated. Even if true, this factor is highly irrelevant here. If at all, it can be seen, in my view, as an aggravating factor that someone who works for the health system and on the face of it enjoys the trust of the community systematically persecutes, harms, and kills people instead of helping them during the conflict. We have already addressed our response to the defense request to submit additional evidence, and we said that no one in Darfur expects or actually deserves to be treated or served by a war criminal. This goes hand in hand with our remarks on the good character of Mr. Abd-Al-Rahman. When looking at how he treated the 4 people, it isn't even within the realm of possibility that the population of Raad al-Berdi would want him back there, running his pharmacy, and the assertion of the defense that he would be needed by his own people in his community is completely irrelevant to the determination of the sentence. Therefore, this argument falls short of constituting a mitigating factor. And maybe as a side note, from another case, Mr. Al-Hassan is also a pharmacist, and despite evidence that he could have a job in the health center in his hometown, and the health center has very limited resource, this did not have any impact on his sentence. Now turning to the defense argument that the voluntary surrender of Mr. Abd-Al-Rahman deserves mitigation. The defense argues that Mr. Abd-Al-Rahman's surrender was voluntary and deserves mitigating weight. This argument should fail. First, any attempt to distinguish within the Ntaganda case is simply wrong. The facts are in fact quite similar. Both accused surrendered because they didn't have the choice. As Mr. Abd-Al-Rahman himself said, he put himself in the custody of the court to avoid having to face the national authorities from Sudan. The defense cannot testify for the accused and provide another explanation, and fail to provide the court with credible evidence that would suggest another reason for Mr. Abd-Al-Rahman to surrender. The defense had the opportunity to submit additional evidence, but did not submit any on this specific matter. The rationale for affording any mitigating weight to this factor is the willingness to cooperate with the court. As it stands, the accused surrendered years after the issuance of the arrest warrant against him, and he had a very personal interest and motive to do so that is not related to cooperation with the court. It should therefore be given no mitigating weight. Further, the defense argues that Mr. Abd-Al-Rahman's good behavior in detention should be taken into consideration as a mitigating factor. The jurisprudence of the court concerning the weight affording to good behavior and cooperation with the court during trial is constant. It is just expected of any accused person. Further, good behavior may be considered to be a mitigating factor if it is found to be exceptional in nature, but cannot in and of itself constitute a factor in mitigation of a sentence. In this case, there's nothing exceptional about Mr. Abd-Al-Rahman's behavior during this trial that could amount to a mitigating factor. The detention unit report simply established that Mr. Abd-Al-Rahman behaved well as a model detainee. This is nothing out of the ordinary. As it is stipulated in the jurisprudence of the court, this is what is expected from a detainee. This being said, I leave it to the discretion of the trial chamber if it wants to attribute any positive weight to Mr. Abd-Al-Rahman's behavior in detention, a matter that is not disputed. Now turning to the defense's argument that Mr. Abd-Al-Rahman presents a good prospect of rehabilitation and absence of risk of recidivism once he is released. The defense submits that Mr. Abd-Al-Rahman presents a very good prospect of rehabilitation and that this should be taken into consideration in determining his sentence. First, the defense's views on Mr. Abd-Al-Rahman's prospect of rehabilitation are not based on any objective facts or relevant evaluation. The chamber cannot simply take the words of the defense to assess this issue. The good behavior and good character of an accused, which is here strongly contradicted by the evidence, as I've explained, is insufficient to make findings, even on a balance of probabilities, on future rehabilitation prospects and the consequences. Moreover, the chamber found in the Blagojevich and Jokic case, the ICTY, that rehabilitation may take place through the trial process, through reflection and hearing the victims testify, and can inspire tolerance and understanding of the other, thereby reducing the risk of recidivism. Reconciliation and peace would thereby be promoted. However, the rehabilitative purpose of sentencing will not be given undue prominence in determining the sentence. This type of evidence is very specific. Rehabilitation prospect and recidivism risk is a very complex and even more for international crimes. Looking at the present case, Sudan is still facing an armed conflict that bears similarities with the one in 2003 and 2004. This fact, combined with the continued denial of Mr. Abd-Al-Rahman regarding his identity, do not point in the direction of rehabilitation. On this very point, the participating victims are very clear. They do not wish for Mr. Abd-Al-Rahman to go back to Sudan, as they are still terribly afraid of him and by the fact that he would reoffend. This risk cannot be discarded. However, if the chamber decided to give some weight to Mr. Abd-Al-Rahman's prospect for rehabilitation, although rehabilitation is a relevant purpose of sentencing, it should not be given undue weight in the context of the crimes adjudicated by the court. Regarding the argument of the defense that Mr. Abd-Al-Rahman did not have prior conviction and this should mitigate his sentence, it is established jurisprudence at the court that the absence of prior convictions does not constitute a mitigating factor, since actually previous chambers found that perpetrators of international crimes rarely have prior convictions. It may constitute a personal circumstance that would have to be considered, but on a balance of probabilities, I don't see how it can constitute a mitigating factor in the present case. Now, another argument of the defense I have to address is Mr. Abd-Al-Rahman's expressed empathy to the victims. Given Mr. Abd-Al-Rahman's line of defense, which is his fundamental right and choice, remorse is difficult to place. But to express empathy for the victims at the same time appears, and I'm sorry to have to use this word again, cynical. The victims don't buy it and feel a further mix of disbelief and frustration. This is what I experienced when personally meeting clients and showing them on the screen the speech given by Mr. Abd-Al-Rahman in December 2024 at the closure of the trial. And this is the feedback I get on the very recent defense submissions. All three defense lines also imply that prosecution witnesses, including all dual status witnesses and therefore participating victims, have either lied or at best negligently failed to state the truth. It is understandable that the accused does not express remorse at this stage, as it is his fundamental right to appeal the trial judgment. However, the continuous refusal by Mr. Abd-Al-Rahman to admit that he is Ali Koucheib inevitably impacts on the sincerity of his words. The defense cannot have the cake and eat it. Mr. Abd-Al-Rahman decided to appeal the trial chamber judgment, and his choice is to maintain that he is not Ali Koucheib. Consequently, the expression of empathy towards the victims in general at the end of this trial, in a short address to the public, cannot be invoked as a mitigating factor, not even in a limited way. The whole point of expressing remorse towards the victims is to try to alleviate the suffering and to contribute to reconciliation. Here, the words of Mr. Abd-Al-Rahman are very general, they are little, they are late, and they do not specifically address the participating victims in this case. Given Mr. Abd-Al-Rahman's line of defense, it is asking a lot from them to accept Mr. Abd-Al-Rahman's words. They don't. Furthermore, the defense is citing the Al-Mahdi case to support the argument that the trial chamber did give mitigating weight to expression of empathy. This is, I'm sorry to say, misleading. If the chamber in Al-Mahdi mentioned the fact that he expressed empathy, it is because he showed remorse and apologized after pleading guilty. Nothing comparable happened in the present case. Now, lastly from me, I have to say a few words to the defense argument that Mr. Abd-Al-Rahman wants to contribute to reparations. I understand that Mr. Abd-Al-Rahman is indigent, and I won't ask him to use the meager income that he earns at the DU to contribute financially to the reparations proceedings. However, Rule 1452A II is very clear. To be considered as a mitigating factor, the accused must make an effort to compensate the victims. Although I obviously welcome the defense's sympathy for reparations for the victims, and the fact that Mr. Lauci personally supports a wide compensation scheme. But this is unrelated to the question of whether this should constitute a mitigating factor for the benefit of Mr. Abd-Al-Rahman. This support to the reparations process must also be put into its context. Firstly, it feels, and I'm sorry to say, like a purely strategic, even if creative move by the defense to propose, as has been done early in the proceedings with your filing 98, a procedure not supported by the ICC legal framework. Also, just as a side note, we received no support from the defense for our application in February 2024 for guidance from the trial chamber regarding the mapping order, so that we could move the reparations process forward for the victims at an early point in time. And this was our filing 1076. Now, on Friday, Mr. Lauci informed the chamber that following a meeting with the trust fund, the defense sent letters to embassies of state and non-state parties, 168 states, to attract, on behalf of Mr. Abd-Al-Rahman, earmarked donations for the benefit of the trust fund, and in particular for the victims of Darfur. I won't say more on this move than that I consider it to be de l'actionnisme, comme on dirait en français, with a certainly good intention from counsel at the outset, at the very last minute, but that coming from the defense may, in my view, even have a counterproductive effect on fundraising for the participating victims. With us, no consultation took place, which is regrettable. Rejecting all allegations and asking for an acquittal, fully knowing that the given ICC legal framework, this would mean zero reparations for the victims, is a perfectly fine approach to take, but should not in any way be considered as a mitigating factor. Again, it is the defense's right to claim Mr. Abd-Al-Rahman's innocence, but he cannot use the victims' suffering and their needs for reparations to mitigate his sentence. The defense cannot have it both ways. And I pass over to my colleague, Maître Beaulieu-Lucier.
Just before you do, Ms. von Wistinghausen. I think you mentioned about defense witnesses talking about women not being killed but raped. I had a double take, so I didn't remember any defense witnesses. I assume you meant prosecution. I think it's a page 54.
If they were called P something, I'm sure there were.
Well, you didn't mention whether it was a P. You just said a witnesses called by the defence, but I'm assuming that you don't, because I don't remember any women being called by the defence.
You're probably right. I will double check, but if I don't get back to you, I'm sure you're right.
Thank you. Yes.
Yeah. So I hand over to Maître Boulieu-Lucier regarding the applicability of Sudanese law, and we decided to address it quite in detail, actually, because we had strong reactions from our clients also regarding this question, which is obviously a legal question, but still there are reactions to that. Thank you.
Yes, certainly.
Yeah, my colleagues from prosecution were helpful. It was P905, I meant. Yeah, so obviously prosecution witness. Thank you.
Good morning, Madam President. Good morning, Your Honors. As my colleague said, the CLRV cannot accept the defense conclusion that Mr. Abd-Al-Rahman should be immediately released or should, at a maximum, be imposed a sentence of 7 years of imprisonment. And this is important for us to address because we did receive feedback from participating victims who said, for instance, that in case of killing, Sharia prescribes specific and severe penalties, and it does not provide age-based exemption. Therefore, if the defense insists on invoking Sudanese law or Sharia concepts, then they must accept that the full application of those systems, including their highest and the most serious penalties. So these are the types of feedback that we receive. V3 said also, we are aware that the Sudanese law contains age-related leniency, but they stress that such exemptions apply to ordinary crimes, not to mass atrocity, not to genocide, and not to crimes against humanity. Age cannot diminish responsibility for crimes committed on this scale. This is their reactions, and this is why we will address the legal standing of this question. Simply put, Your Honors, it was foreseeable for Mr. Abd-Al-Rahman that the crimes he was found guilty of were going to attract a severe penalty in light of the intrinsic gravity of the crimes he was convicted of. The first argument of the defense is flawed. The defense cannot argue on one hand that the most severe punishments are not legal under the Rome Statute, but on the other hand, argue that the only punishment left that was applicable in Sudan at the times the crimes were committed is a sentence of 7 years imprisonment. There is a range of sentence between 7 years of imprisonment and death penalty. And the question the defense should have asked themselves is not what is the next highest sentence available under Sudanese law after the death penalty or crucifixion or corporal punishment, but rather what was available under the statute and what was foreseeable by the accused, and what existed in international sentencing practice. The defense did not apply the right interpretative standard to approach the principles of legality and of non-retroactivity. The appeals chamber in this case, in its decision on the defense jurisdictional challenge, did set out the interpretation test to assess if there is a violation of the principle nullum crimen sine lege, and when applying it, found that there was no violation of Articles 22 and 24. and that the accused could be prosecuted for the crimes he was charged with. And the trial chamber, Your Honors, found at paragraph 28 to 60 of the trial judgment, you arrive to the same conclusion. Here we are concerned with the principle of nola poene sine lege, which is less stringent than the nullum crimen principle. In any event, whether we apply the foreseeability test applied by the appeals chamber, or if we look at international sentencing practice, the result is clear. There is no breach of the legality principle, nor the non-retroactive principle following the potential imposition of a sentence higher than 7 years of imprisonment. If we start by applying the two prongs foreseeability test, and first, we ask ourselves, is the law was sufficiently clear and accessible to a person in the circumstances of the accused? We looked at the Rome Statute, which has codified the applicable law at Article 78 and 77 and 78, and there's a consensus that the nulla pene principle does not bear the requirement of lexa certa, that is, specific sanctions or determined penalties range applicable for each crime. Rule 145 explicitly set out the factors that may have an impact on the determination of the sentence. And the sentence must reflect the gravity of the offenses. Second, when we look at if the punishments must have been foreseeable, we must apply the reasonable standard. The fact that a reasonable person could have expected at the time of the events to face a sentence that would correspond to the gravity of the crimes committed. In the jurisdictional challenge decision, the appeals chamber decision, when applying this test at paragraph 88, already found that Mr. Abd-Al-Rahman was reasonably capable of taking steps to comprehend and comply with his obligation under international law, and he was capable of appreciating the attendant penal consequences, notably considering his time in the military and his background. Judge Ibanez further noted that the content of the statute, including in particular the crimes under its jurisdiction and the applicable penalties, has been public since the adoption of the statute. She also noted that although Sudan has not ratified the Rome Statute, it did sign it in September 2000. Therefore, the law was public and was known for Sudan and for the accused. The appeals chamber, and now Your Honors in the trial judgment in paragraph 28 to 60, found that Mr. Abd-Al-Rahman was in a position to know that his conduct would attract criminal responsibility for the offense he has been found guilty under the Rome Statute. It logically follows that he was equally in a position to understand the nature and the range of punishment that could be imposed for such crimes. It is also relevant to examine whether a sentence up to 30 years of imprisonment for these crimes existed under international sentencing practice or was found in other source of law at the time of the crimes. While the answer might be less straightforward than for the nulla crimen sine lege principle and challenge, it remains nonetheless a positive answer. The punishment provides under the statute do not go beyond what existed in 2003 and 2004 in terms of sentencing for similar crimes, nor do they exceed the penalties prescribed under Sudanese law at the time. If we go back, historically, the Nuremberg tribunals applied death penalty, while both ICTY and ICTR imposed life imprisonment. The ICTY appeals chamber found in the Blaskich appeal judgment in 2004 at paragraph 681 that the trial chamber did not violate the principle of nulla poene sine lege because an accused must have been aware that the crimes for which he is indicted are the most serious violation of international humanitarian law, punishable by the most severe penalties. And since 2002, Articles 77 and 78 and Rule 145 have expressly set out the penalties available before the court and the factor that would affect the determination of the sentence for international crimes under the statute. When we look at the sentences provided in Sudanese criminal law for crimes of similar gravities as the convicted crimes, such as rape and murder and attacks against civilian population, the sentences for those crimes were extremely high in 2003, 2004, including death penalty, corporal punishment, and imprisonment for up to 30 years under the 1991 Criminal Act and the 1986 Armed Force Act. It is also noteworthy that the crime of murder is a crime of qisas, and the crime of zina is a crime of hudud that prescribe hudud. And crimes of qisas and hudud are crimes excluded from the 7 years old exemption. And this is something that your honors found and have noted in the trial judgment at paragraph 44. And that being convicted for those crimes in Sudan would attract death penalty and corporal punishment, no matter the age of the offender. And this is found in paragraph D16 statement at paragraph 24 and 26 for murder, and paragraph 48, 49 for rape, and even ordering rape at paragraph 54 attract the same penalty as a direct perpetrator. It is therefore unequivocal that the penalties at the ICC are, in fact, more lenient than those previously applied for comparable crimes by other international tribunals or in Sudanese criminal courts. And accordingly, the accused was on clear notice that the type of conduct in which he engaged would attract the most serious penalties under international law, namely substantial terms of imprisonment. In the alternative, the defense argues that the application of the statute constituted a change of law between the charge period and the Security Council's referral in 2005, and that as a result, the accused should benefit from the most favorable sentence in line with Article 24(2), namely a maximum of 7 years imprisonment. And with respect, this argument is unfounded. First, the defense provides no support for the position, for their position that the Security Council resolution changed the law applicable in Sudan. The mechanism under Article 13b provides for the exercise of jurisdiction by the court in the case at hand, which necessarily means the application of the court's legal framework before the date of the referral. Also, Article 24(2) of the statute applies the substantive law of the statute, and following Ruto and Sang appeals decision on the prosecution request to admit prior recorded statement. That article does not concern domestic law. There have been, and most of all, there have been no amendment to the statute on sentencing since 2002, and accordingly, there can be no violation of Article 22 in this case. Second, the defense submits that the Sudanese law was the most favorable because it provided for a maximum of 7 years imprisonment. However, the Sudanese law actually provides for death penalty and corporal punishment. Those harsh punishments are obviously not available under the statute. However, it is broadly the case that states that have abolished death penalty replaced it with lengthy custodial sentences. Therefore, even if the chamber were to consider the defense alternative approach, the logical outcome would still be that the accused faces a sentence well above 7 years. There is no violation of Article 23 or 24, and this line of argument must accordingly fail. And at last, we reject the arguments of of the defense that the crime of Hiraba does not apply in this case and warrants immediate release. In the context of the attack on Bindisi and Kudum, it is safe to say that there was no possibility of rescue, one of the ways to establish the commission of the crime of Hiraba. According to P29, the police officers did not have equipment or means of transport, and after the rebels attacked Bindisi, they withdrew to Mekjar. Following the withdrawal of the police officers, villagers organized a popular defense group, but they had no weapons, nothing to defend themselves. And P29 said himself, "We were defenseless. We could not defend our possessions, our livestock. They took everything anyway, because on the other side, they had weapons. We were defenseless. You can't do anything about it." Any other conclusion than the commission of Hiraba would be wrong. Immediate release is therefore obviously not a suitable consequence of the grave crimes committed by the accused. And to briefly conclude on the legal representative submissions for today, Mr. Abd-Al-Rahman chose to surrender to the ICC rather than to face domestic prosecution in Sudan. He knew the risk he would have to face there, and he knew what was awaiting for him here at the ICC. He must now accept the consequences of his choice, consequences that are potentially far milder than the one he would have to expect back home. Thank you, Your Honors.
Before you sit down, you've been arguing that the defense have misinterpreted Sudanese law. You're not arguing, therefore, that it doesn't apply at all, as really set out in Bemba and Ongwen, that it's the statute that applies.
Thank you, Your Honor. It's the statute that applies, but you can, if for the foreseeable test and to assess if the accused could have foreseen that these crimes were applied, we can look at the criminal Sudanese law to see what he could have foreseen was applicable even in Sudan at the time of the crimes.
I'm still not clear. Are you arguing that it is permissible for the trial chamber to look at Sudanese law, as indeed the defense are inviting us to do, rather than, in fact, saying that Sudanese law is inapplicable and that the powers of the trial chamber are limited to the identification of the appropriate penalty amongst the ones listed in the statute and a determination of its quantum?
I believe that we have cited in our sentencing observation to jurisprudence at the ICC where the previous chambers were clear that what is applicable in terms of sentencing quantum at the ICC is only according to the Rome Statute, and
right.
The domestic law is not applicable. It's more in terms of a guideline of what was foreseen.
I just want to make it clear because it wasn't altogether clear.
My apologies, Your Honor.
Yeah,
Thank you
right.
for the question and the opportunity to clarify.
All
in
right,
that case.
thank you. Yes. That concludes your submissions, does it, Ms. at this stage?
Yeah, well, that concludes today's submissions, which was merely like a response to the defense submissions, and we will bring our own conclusions before you at the end of the sentencing hearing.
Yes,
Thank you.
very well. Thank you very much. All right. In that case, I think we'll break here. But before we do, there is something which has been raised, I think, by both parties, and this is. I think you need to address us on that. You've submitted, Mr. Lacci, I rather feel it may be Mr. Edwards, but that we should be applying the balance of probabilities, which I agree is oddly enough, although he doesn't seem to mention the word, the balance of probabilities anywhere in the statute, and the test, I'm told by my civil law colleagues, doesn't exist in the civil law. But you've been arguing in a number of different places in the brief that the test is not beyond reasonable doubt. Now, it is when we should be making factual findings in your favour on a balance of probabilities. But you're referring, and I can find some examples, but I'm sure you can find them yourself, if you like, after lunch. You are referring to factual matters where, had we not been satisfied beyond a reasonable doubt, or convinced, as the test is here, that certain things had happened, and we find certain things, we couldn't have found Abd-Al-Rahman guilty, or certainly we couldn't have made a positive assertion. So I'm not quite clear how you expect us to operate that.
Thank you, Madam President.
I mean, if you want, I can find you an example.
I think I can find an example, and I think your question perfectly fits, is perfectly relevant, especially for our argument on defense line 3, which was mentioned by my learned colleague. Defense line 3 was proposing you to find that Mr. Abd-Al-Rahman believed he was acting on the basis of order and had no choice. And in your judgment, you found that the evidence that we had provided in support of this defense line was not enough for your finding beyond reasonable doubt. We respect that fully. Now we are turning to a new phase, which is a discussion on mitigating circumstances where the standard is lower. And the standard is, as you said, the balance of probabilities. So it can be, you may consider it as a kind of recycling, but indeed, what did not succeed beyond reasonable doubt still has a chance of succeeding on the balance of probabilities. Hence, the reason why we kept this element in our first, if I'm correct, mitigating circumstances in the brief.
Well, I'm sorry, I think you better turn to paragraph 58 of your it's what I happen to have marked, of your submissions. Yeah.
Let me read it.
It's the part where you say it's good. I mean, it's under his positive good character, but you say, if they didn't pass, the defence is aware of the Chamber's findings as to the reliability of the witnesses. But if they did not pass the beyond reasonable doubt test on key issues such as the alias Ali Kushaib, but I'm sorry, how can we ignore the fact that we were convinced beyond a reasonable doubt that it was Al-Rahman, I'm sorry, I'm mispronouncing him all the way through, Al-Rahman's, that he was Ali Kushaib? How can we suddenly say, well, actually, we're not sure?
This paragraph is not at all suggesting you so. And the reason for that is that the premise of all the defense's submissions on sentencing is your trial judgment. So it is what is found in your trial judgment is no longer discussed at all. What is important here is that for these witnesses that are mentioned in this paragraph, your reasoning was to say, we do not find them credible because, and especially because they say that Mr. Abd-Al-Rahman was not Ali Kushaib.
Was never known.
Whereas we, the chamber, find beyond reasonable doubt that he was Ali Kushaib. That's one aspect of the evidence. Now we ask you in this paragraph, and my learned colleague Yedin Warts will elaborate on that this afternoon, or maybe actually tomorrow, is that it's not the only portion, the only topic of the evidence of these witnesses. You were not convinced by them saying Mr. Abd-Al-Rahman is not Ali Kushaib, but they say also that he was a man of good character and that he did something positive for his community. We believe, and especially on the balance of probabilities, that your finding that Mr. Abd-Al-Rahman was Ali Kushaib, beyond reasonable doubt, is not an impediment to considering the other aspect of the evidence of these witnesses of what he did or not for his community.
Yes, all right. I think I see. You're saying that on actual issues that were the subject of dispute in the trial, such as the obvious one, the
Yes.
Abd-Al-Rahman was known as Ali Kushaib. You're not seeking to go behind that, but you're saying on other evidence that didn't directly go to an issue in the trial, we should consider that evidence on the balance of probabilities.
I believe the door is still open to you, Your Honours, to follow.
Yeah, well, I mean, yes. I mean, I think what confused certainly myself and possibly my colleagues as well was that you seem to be saying that we could examine evidence that we had already found against your submissions as part of the trial. We could have another look at it and decide whether or not, for the purpose of sentence, on the balance of probabilities, we would have preferred it, we would have accepted it, which it would be impossible, because if there had been the balance of probabilities, we couldn't have been satisfied.
This was not our submission. I hope it is clarified.
Yeah, all right. Yes, thank you very much. Yes, in that case, we'll say 2:30 then, yeah.
Prijs, we willen bij.